In this lecture, we're going to examine competence in the legal system. Now, competence is different from some people. When they think of competence, they're thinking about not guilty by reason of insanity. And in fact, that's not what we're talking about when we're talking about competence in the legal system. Let's examine a couple of cases. When we're talking about competence, this is really what we're talking about. It's during trial, the competence to stand trial, the ability to understand what's going on in the courtroom and to help with your own defense. Let me give you just a couple of cases, some that you might know of. The first one is the Elizabeth Smart case, and many of you may have heard about this case. In 2002, a young girl by the name of Elizabeth Smart was abducted from her home in Utah. She was found 9 months later, and the couple who kidnapped her were Brian Mitchell and Wanda Barzee. There's Wanda Barzee right there, and there's Brian Mitchell. Now, what you may not realize is that even though they caught this couple 9 months later, the trial of both of these individuals was initially postponed because both people were found not mentally competent to stand trial. So, in other words, because of mental illness, they were not able to help with their own defense. Brian Mitchell was declared competent in 2010, but then another psychiatrist found him incompetent, and this went back and forth. And it wasn't until about 6 years later, the trial still hadn't taken place. And at this point, the statute of limitations for their kidnapping charge was about to run out. And so what happened in this particular case is the feds, they charged this couple. Because remember, if you know anything about this case, Wanda Barzee and Brian Mitchell took Elizabeth Smart across state lines, making it a federal crime. So what they did then was they increased the statute of limitations, allowing them to continue this case. It wasn't until 2011 that this couple finally was found competent to stand trial. Mitchell was sentenced to life in prison after being in psychiatric custody for 6 years, and Barzee pled guilty, and she's also serving time as well. So there you have an issue of competence. Another case that you may know about, this gentleman here, or I'm using the term loosely. You may remember Jared Lawner. He was charged in January 8th, 2011 with the Tucson shooting. He killed 6 people and left 14 injured, including one of the people that he injured was Gabby Giffords, who was a representative. He also killed a judge and a 9-year-old girl. On May 25th, 2011, he was ruled incompetent to stand trial. Again, because of mental illness, he was not able to help his defense. In June of the same year, the court ruled that Lawner could be forcibly medicated to make him fit to stand trial. So in other words, although his mental illness was keeping him from being able to understand and mount a defense, the court ruled that he had to undergo forced medication. As you can see, the courts don't always agree. A federal appeals court reversed the earlier ruling. And then finally, a year later, Jared Lawner pled guilty to 19 counts and was sentenced to life without parole. Now, in order to plead guilty to those 19 counts, the state would have had to make him competent to stand trial. Okay, so let's take a look at competent to stand trial. Okay? When we're talking about competent to stand trial, we're talking about competence at the time of the trial, not at the time of the crime. Now, this is different from the insanity defense. The insanity defense says that you were insane at the time that the crime was committed, not at the time of trial. The history of competency is such that, for example, in the 1960s, if somebody raised this issue, for example, you were not competent to stand trial, what would end up happening is you were often sent to an institution and pretty much forgotten. So in other words, you would never stand trial. Give you an example. A study that was done in the 1960s found that most people who were found incompetent to stand trial were sent to an institution and were still there 10 years later. Okay, and in Massachusetts at that same time when they were doing this study, the most common way of getting released was to die. You went out in a box. Okay. Another study in New York found that 40% of people who were found incompetent to stand trial were never ever convicted of a crime. In fact, they were simply warehoused in institutions. And in fact, then patients were not receiving treatment to make them competent. And of course, the courts had to get involved. So, Dusky versus the United States, 1960. This is the Supreme Court weighing in here. And they defined what it meant to be incompetent to stand trial. So this is where our definition comes from. According to the courts, if you're unable to assist in your own defense, you may be incompetent to stand trial. If you're unable to understand the charges, you may be incompetent to stand trial. And if you're unable to make legally relevant decisions, you may be incompetent to stand trial. Now, what kinds of legally relevant decisions do you have to make when you're going to trial? Obviously, one of the most important ones is whether to plead guilty or not guilty. And so if you're unable to understand those charges or unable to make that decision, you're incompetent to stand trial. So what was happening in the United States was that incompetency was being raised quite a bit in the United States. But after this particular case, the number of incompetency cases dropped. The main point that the court made, though, is that when someone is found incompetent, it's assumed that it would be unfair to continue the criminal process until the defendant is found competent. So how does IST occur, incompetency occur? Well, usually what happens is somebody makes a request pretty early in the criminal proceeding. An attorney makes the request, probably the defense attorney. But in fact, anyone can raise the issue of incompetency. Anyone in dealing with the defendant can say, this person is not competent to stand trial. And once the issue is raised, it is rarely denied. So in other words, if somebody raises the issue of competency, it's rarely denied. So once the issue is raised, what happens then? Well, they're going to undergo some testing and some evaluation. Before we talk about that testing, let's talk about how often this occurs. About 25,000 cases annually, you have an IST that is raised at trial. So about 1 in 15 defendants, which is quite a bit if you really think about it. And it turns out that 70 to 90% of the times that this is raised, the defendant is in fact found competent. So it would be unusual for a defendant to be found incompetent to stand trial. So even though it gets raised a lot, typically people are found competent to undergo trial. So how is competency assessed? It's interesting that we have this very important part of our legal system. So think about it this way. You have the legal system. This is where psychology and the legal system sometimes don't work really well together. The legal system says that this person is incompetent, or they think they are. So they hand the person over to the mental health system. And typically, they hand them over to some inpatient facility because think about it, this person's committed a crime. We don't want them walking around the streets. We think they're incompetent. Okay? And then what we do is we ask psychologists or psychiatrists, mental health workers to come up with a decision about whether this person is competent. The interesting thing is that there is no set criteria for how the clinician is going to go about assessing this person. There is nothing in psychology and there's nothing in law that says, you need to do these kinds of tests and establish these kinds of things in order to make your decision. But a clinician will do it anyway. They will do an assessment, and then they will send that report to the court saying, yes, I believe this person is competent, or no, I don't think this person is competent. And the report that the clinical person writes, the psychiatrist or psychologist, is often accepted by the court. So judges will rarely disagree with a report. And this is kind of interesting because this competency assessment is made on the basis of one clinical assessment. And the legal courts, they accept the assessment based on the clinician's report. Clinicians often don't even testify in court as to how they tested the person and what kinds of criteria they use. So this is one of those places that psychology and law are probably not communicating really well together. So what do clinicians use? Now, I'm going to go over a couple of the competency assessment instruments that are mentioned in your book. Honestly, I don't care whether you know these assessments, but I just want to give you an idea of what this is about. So the first one your book talks about is the competency screening test. The defendant will complete 22 sentences. There'll be a sentence stem. For example, the assessor will say, Jack felt the judge would, and then the defendant's supposed to answer it. And if the answer is incompetent, they get a 0. If it's questionable, they get a 1. And if it's competent, they get a 2. A score below 20 is usually seen as not competent. The thing is that you've got this assessment, but there isn't really any true way to score this. So for example, you've got this sentence stem that I just gave you. Jack felt the judge would. Well, I suppose you could say, let's say the defendant said, Jack felt the judge would be fair in the trial. And you'd say, oh, that's a reasonable statement. I'll give this person 2 points. Well, what if you're the defendant and you don't think the judge is going to be fair? And so you say, Jack felt the judge would screw him over. Well, I would say that I'd give you 2 points. Does that really assess your competence or your beliefs? So again, some problems here. Another assessment instrument that's mentioned in your book is the competency assessment instrument. It's an interview that lasts about an hour. You're supposed to score 13 observable groups of behavior relating to the defendants. And again, there isn't really any real structure to this thing. You judge 13 behaviors in terms of incapacity to full capacity, and there's no set point for at what point you're not competent. The next one is the IFI, the interdisciplinary fitness interview, and this is a semi-structured interview. Semi-structured means that most of the questions that you're supposed to ask are kind of written out, and you're supposed to try to follow this as much as possible. And again, there's no real specific way of scoring it. Finally, the Georgia Court Competency Test. It has 21 questions, and it really taps legal knowledge. Like, do you know about the courtroom and the layout, what the different players are doing and things like that? Okay. Most people who do competency evaluations will use one of these 4 tests. But there is a question here. I mean, these really do not meet criteria for what most psychologists consider good, scientifically validated instruments. A question that comes up a lot is, think about these competency tests. And the question I would ask you is, do you think you could fake incompetency? In other words, do you think you could fail this test if you wanted to? Go back for a minute to the Elizabeth Smart case. As I told you, for Brian Mitchell, he didn't pass competency for 6 years. And then there were a lot of people in that case that felt very strongly that Brian Mitchell was malingering. Malingering meaning he was trying to fake incompetency. And a lot of people suggested that Brian Mitchell was actually a psychopath, a very smart, manipulative person, and that he was manipulating the system to fake incompetency. So again, think about this a little bit. Could you fake incompetency? And that's one of the big criticisms of this test. So let's suppose you get a competency assessment, and what happens after that? Well, obviously we send the report to the court, and as I said, in the 1960s, once you were found incompetent, you were just simply put in an institution. It wasn't until 1972, though, that the courts kind of weighed in here. This was a case that involved a 27-year-old man. He was deaf and mute, and he had some mental disabilities. He was accused of stealing $9 worth of candy. He was declared incompetent, and he was committed to an institution. Now, experts said that there was really no hope of him getting better. So the question is, would he spend the rest of his life in an institution for selling $9 worth of candy? And in fact, the court said no. There are legal limits to confinement, that people who are found incompetent to stand trial have the right to get treatment. Okay, so that if there is no way to treat, we need to use some other criteria. People have the right to have that treatment make some progress so that they can stand trial. And the courts also said that you have to the legal confinement has to be limited. So we can't simply put you in an institution for the rest of your life for stealing $9 worth of candy. In most states now, the criteria that they use for the confinement is that the confinement cannot exceed 2/3 of the maximum term that you would get if you were charged. Okay, $9 worth of candy would obviously be a misdemeanor. Most misdemeanors, at the most, you could spend a year in jail. And so the confinement cannot be more than 2/3 of a year. So there are limitations to incompetency. So let's talk a little bit about some special cases. There are some cases where the courts have weighed in and tried to decide whether or not you're incompetent. One special case is amnesia. Suppose there was a crime, you don't have a memory for it. Are you incompetent to stand trial? The courts actually say not necessarily. You're not necessarily incompetent. And the court will decide this on a case-by-case basis. And the main criteria they use is whether the amnesia would interfere with you preparing a defense. Obviously, if you have complete amnesia to the entire event, that would keep you from preparing a defense. But the court will decide on a case-by-case basis. So amnesia in and of itself does not lead to incompetency. Another issue that the courts have grappled with is competence with medication. With Jared Lohner, as a perfect case, the courts wanted to medicate him, and he was trying to refuse. Can the courts force you to be competent to stand trial? And of course, this is one where the courts again had to weigh in. This is Sell versus the United States. In this particular case, the court ruled that yes, the courts can force treatment. And the treatment, but the state doesn't have unbridled, rights here. The treatment that they give you has to be medically appropriate for whatever it is that's keeping you from being competent. The treatment also should not have side effects that keep you from being able to mount your own defense. So if the side effects were such that you couldn't stay awake, then the courts might consider that a big deal. And then finally, we can force treatment if the treatment is necessary to further important government trial-related interests. And this is pretty broad because the courts can decide that it's so important for us to convict Brian Mitchell that it's important for us to medicate him against his will. So, in other words, the court gave some pretty broad brushstrokes, some broad rights to the states to actually force treatment. Before we end this particular session, I just want to mention that there are other competence issues as well. So, I talk about competence to stand trial, but competence can come up at any phase of the trial. So, for example, you have to be competent to plead guilty. So someone might be competent to stand trial, but at the time they have to go before the judge and say whether they're guilty or not, they may have mental illness that's keeping them from understanding this. So competence to plead guilty. Let me just give you a little side note here, because this is a big issue. It's not just mental illness that could make you incompetent. If you think about children, how old do you have to be competent to understand what it means to plead guilty? This is something that's come up quite a bit in the courtrooms. At what age do you understand what pleading guilty is? Again, another competency issue is, at what age are you able to waive your Miranda rights? So suppose you read your Miranda rights and you say, I waive those rights. If you're incompetent to waive those Miranda rights, then the courts will say that no, you were not able to waive those rights. Another thing is the competency to refuse the insanity defense. So because the insanity defense might be mixed in with issues of competence, suppose you're mentally ill. Your attorney says, we're going to plead not guilty by reason of insanity. But because of your mental illness, you're not able to say, no, I don't want you to do that. So the courts will then decide that you're incompetent to make that decision. And then again, we might force treatment on you to force competence. And this is the last one, is the one that I think is the most unusual, is that you actually need to be competent to be executed. So if you have been found guilty of a capital crime, you're on death row, your execution is coming up, and at this point in time, because of mental illness, you're not competent to understand what this execution means, you can't be executed. And in fact, the courts have decided that the state can force medication on you to make you competent so that we can kill you. I think this last one just shows you that sometimes the decisions by the legal system might make logical sense, like Spock-like logical sense, but be a bit nonsensical in the long run. Okay, so what I've done this time is try to cover the issue of competence for you, and next time we're going to be talking about the cousin of competence, which is the NGRI, or not guilty by reason of insanity defense. Thank you.